to mute yourself. Also, do not click on share the screen option. Otherwise, your screen will be shared and visible to all. Only presenters should share their screens while presenting. Thank you, everyone. With the recent COVID crisis and the resultant disruption, a number of projects have got delayed or affected. This has led to numerous contractual issues, including delay and damage claims. In any infrastructure sector, including water and wastewater management, the leading contracting firms are facing issues related to construction law and contract management. To address these concerns, everything about water and Marsin project are happy to organize this webinar on COVID-19 claims, delay damages, and construction law. Leading Indian and international legal experts on arbitration and claim management will be sharing their perspective and expertise. We invite the audience to make this an interactive exercise where they can raise their queries and gain expert advice from seasoned veterans in this field. I request you all to ask your questions in the chat box. We look forward to an absorbing and value-adding session. I am happy to now invite Mr. Rohit Singhal, CEO of Marsin Project, who is one of the speakers in our panel today and also moderate this session. Mr. Rohit Singhal.
Good afternoon, everyone. My name is Rohit Singhal. I'm sorry for the small delay. There were some technical issues which the backend team is trying to resolve. But I
it's all about delay, Rohit. It's all about delay. So good auspicious start.
Welcome to all. I'm sure this session is going to be very interesting and lively for all of you. We are not going to talk any theory in this session. We are taking up issues which we see are day-to-day issues which each and every industry practitioner, construction industry practitioner is facing, like a contractor, an employer, or an engineer. So we are going to talk about the practical aspects of today's construction industry with very strict focus to Indian construction projects. And I have a very esteemed and expert panelists who have joined me. Before that, I'll just give you a small presentation which talks about what we are going to talk today. So first, let me just give you a brief about what Marsin, the company which I represent. We are India's leading construction and engineering consultants and experts. We have offices in 7 countries, including in India, Delhi and Mumbai. We primarily are not lawyers. We are experts for handling delay disputes, the quantification of disputes, or technical areas of dispute like variations, scope changes, and all. We are a team of around 90 highly experienced experts with industry knowledge, having done projects on our own. So we know the ground conditions, what a contractor or an employer or an engineer is looking for. As a company, we have appeared in more than 200 Indian and international arbitrations. We have done more than 500 assignments on various type of claims and disputes ranging from, in Europe, Americas, India, Middle East, Southeast Asia, Africa, and all. Our total value of claims which we have handled till today is almost close to around 20,000 crores. Besides that, although we are not lawyers, but we have a strong link with the renowned Indian and international law firms and have good understanding of construction law. The panelists who are going to be there today are Mr. Gopal Jain. He is a senior lawyer, designated senior lawyer. Mr. Jain is a designated senior advocate by Supreme Court of India. He has 25 plus years of experience in arbitration and commercial litigation. He has represented Indian and multinational clients in complex and contentious commercial dispute. His areas of practice are commercial arbitration, infrastructure, policy and regulatory dispute. He has advised the telecom and cellular industry and has also represented a number of PSUs, including ONGC, GAIL, DMRC, and central and state governments. Welcome, Mr. Jain. Then my second panelist is Mr. David Brown. David is from Clyde & Co. Paris. He's a construction partner with Clyde & Co. He has wide range of experience of international construction and dispute resolution matters. His dispute resolution experience notably involves international arbitration as both counsel and arbitrator concerning a broad range of commercial matters in addition to construction. He features on the FIDIC's President list of adjudicators a very renowned list, as well as the FIDIC French national list. Welcome, Mr. David, to this webinar. The third panelist who is going to support this discussion is Mr. Anirudh Krishnan from AK Law Chambers. Anirudh Krishnan is the managing partner of AK Law Chambers. He specializes in arbitration and commercial dispute resolution and insolvency laws, and regularly appears before various domestic forums and international arbitral tribunals constituted under various rules, including ICC, LCIA, SIAC, AMTC, etc. He has been awarded the Rising Star 40 under 40 by Legal Era, and has, on being invited, contributed a chapter on his life story in the book titled On the Rise. I welcome Anirudh to this panel. The topics which we are going to today discuss in this webinar are: number one, the COVID-related disputes, the Indian law perspective to the various COVID claims. You know, everybody in the construction sector has been affected by lockdown and disruptions and delays caused by COVID. We are going to discuss this during this panel. The second issue which we are going to discuss about is a very often thing which comes in front of contractors and employers, is that what happens if a contractor fails to issue notice on time as per the provisions of contract. I will request everyone to mute themselves, because otherwise it will create disturbance in the section. Third issue which we are going to discuss is what happens, can a contractor claim and go for an arbitration when he has issued a no claim certificate confirming that there are not going to be any claims which are going to be raised by the contractor. Then third topic which we are going to discuss is on the liquidated damages, that can an employer claim damages beyond the liquidated damages if there is a delay by the contractor. Fourth is, can an arbitral tribunal or a judge award liquidated damages less than what is specified in the contract. Now, all these issues are going to be taken from an Indian law perspective. Then we will also discuss the international law perspective, where David is going to give his opinion on that, how construction disputes are handled in ICC arbitrations. Then he will be specifically dealing with some examples pertaining to delay claims, the need for expertise in the team, the lawyer, the legal team, the expert team, or the arbitrators. What should be the kind of expertise which should be there in these teams. And then he is going to talk about how to handle delay claims from an international perspective, including a concurrent delay situation where both the employer and the contractor are under delay. And lastly, he's going to talk about COVID-19 claims. He's going to give us the international perspective to that. Then third major issue which we are going to discuss today is the unfair contract conditions, when the contract is not balanced and there are provisions in the contract which are not fair from an employer perspective or a contractor perspective. So we are going to talk the Indian law perspective, that when a contract has a provision that in case of a delay caused by the employer, only time extension is going to be granted, no cost. So how Indian law sees that. Then how Indian law deals with concurrent delays is the next point which we are going to deal with. Then what happens from a perspective where a contractor, while entering into a contract, is unable to foresee certain risks which are beyond its control, and what happens in such an instance, how does Indian law deal with. One of the very common disputes which we see is the unforeseen ground conditions, the soil conditions being different than what are specified in the contract. And then another important point which we see, as claim consultants very often taking place in construction industries, that the employer or the main contractor does not make payments on time to the subcontractor and all. So how do you deal with that? And then lastly, we are going to talk about the concept of practical completion, when the entire work has been done, entire job is finished, commissioning is done, but there are some minor issues like snag issues, punch list points, which have not been completed. What happens from that perspective? And then lastly, I'm going to deal about prolongation claims. What should be the cost which should be included in the prolongation claim? How to deal with a loss of productivity claim? And then what to do with when there are concurrent delays. And I'll also touch base upon how delay analysis is done and what are the advantages of doing a delay analysis. So these are the broad issues and topics which I'm going to discuss, which we are going to discuss as part of this webinar. And now, before taking up the topics, I'll just give the floor to Mr. Gopal Jain to set the tone for this webinar. Mr. Jain.
Good afternoon, friends, and thank you, Rohit and the Mason Group for this opportunity. Rarely has the world seen a worldwide phenomena which has affected the lives of each and every one of us on the planet, and also thereby affected businesses almost being life-threatening and caused complete havoc and disruption in the way in which business is done and in which business will be done. We use expressions like unimaginable, unprecedented, unthinkable. But if at all there is a situation which squarely fits into the expression unprecedented, unimaginable, unthinkable, it is this situation. And I don't think any contract or law could create a situation where the entire world at the same time will be facing the same malaise, the same disease. And therefore, the way, the lens through which we look at it will have to be vastly different from what we have seen. It therefore gives rise to enormous scope for innovation, out of the box thinking, and, if I may say so, to exit from a situation honorably, perhaps keeping relationships intact. Now, while this has had a huge disruption on business, on work conditions, and business has to adapt to this, equally, the conditions caused not just by the epidemic, and this is the point I'm emphasizing, in the world and in India, has been followed by lockdown and a series of orders, directives, and instructions from the central government, the state governments, and a multitude of agencies and local authorities, all of which have to be complied with by all, including contracting parties. Now, while business will undergo a change and will adapt, these measures have what I call a very long-lasting effect, long-lasting repercussions. Not all of them can be assessed today as we speak. So the next question which then comes for our consideration would be, how is the situation to be viewed? How is the situation to be addressed? Because many of the issues which we'll be dealing with and the questions that Rohit mentioned will have to be seen in a context and perspective. And of course, you have the contractual provisions and the extant law. But I am now going to place for your consideration some mantras, because all of us as Indians, whenever we are in a distressed situation or we face a problem, we always have some mantras to go back to. And like the spread of the virus, I think we're going to have a spread of disputes which are going to be on the rise. It will be a battleground of disputes. So parties have to be responsible litigants who have to have an approach which makes them credible and which will then have a different kind of traction and receptivity when it goes through the process either of resolution or of dispute management or actually of adjudication. So we all are frontline warriors for you, trying to find ways and means by which we can address a range of issues, and therefore to bring some uniformity and consistency, here are some suggested mantras that we could consider. The first is what I call, at hand are commercial transactions and a commercial deal. There's a commercial bargain. It's this bargain which is captured within the four corners of what we call a contract or an agreement, but the heart and soul is a commercial deal. So it's this deal which has to be kept intact. It is this deal which has to be honored. And what is the deal? The deal is always about economic feasibility, economic viability, and securing a fair return on a project which is done. And the Supreme Court of India, in a judgment 2 years back, recognized a principle called business efficacy. It essentially means when two parties, two business partners, came together on a commercial understanding, if at all there's a dispute, the fundamental guiding principle should be what is it that the two parties intended commercially, and it is that which should be given effect to. It's called the principle of business efficacy, to produce the results which parties intended. So when we look at the framework of a contract, now naturally it has certain clauses and stipulations, but the commercial intent is the one which is the heart and soul, and that must be given effect to. And the first mantra therefore is keep the commercial deal intact, think of the principle, apply the principle of business efficacy. The next mantra which follows from this is, at the end of the day, all projects have project economics, project dynamics. It's about economics and finance. So the Supreme Court, again, in a case called Shiv Shakti Sugar, said, look, in a situation like this, apply economic principles to law. There is an interplay between economics and law, because financing is at the heart of deals in infrastructure and construction. And even though it may not be a part of the contract, but it really controls and governs the project, its completion, its continuity. And these interests are equally vital, because unless the project finance and viability is kept intact, the project may have hardship, lenders may have hardship. It overall has an effect on the business and commercial environment. So the second mantra is the interplay of economics and law. Contracts have to be seen in this wider lens, applying economic business principles in giving it meaningful interpretation and shape. Third, the Supreme Court itself has said, and repeated this over the years, that you have to look at the context. And they use the expression, marry the text with the context. Now, if at all there was a case where the context became of such paramount importance, it would be post the pandemic, the lockdown, and I said the disruption and the dislocation which has been caused, the exceptional circumstances, the unthinkable, unimaginable, unprecedented. So you have to marry the text of a contract with the context, which we've just mentioned, and marrying the two, we have to produce a just result, as I said, as the parties had intended. The next principle is the law is always dynamic. We have judgments of the Indian Supreme Court, friends, which had upheld the vires of a law, and no pun on the word virus, and 10 years later struck down the very same law, saying, oh, the context had changed. There were subsequent events, developments, and circumstances which had taken place, and quashed the very act which they had upheld. In the last 3 months, where we've seen COVID-related cases, I want to give you 3 examples of what was a 100% U-turn. We first had a case where the court said all private testing will be done free of charge. Within 3 days, the court reversed its decision. 3 months back, there was an instruction or a direction given by the central government that everyone, every party, private or public, will continue to pay labor its wages, salaries, and emoluments. This was brought into question to say, look, how can you give a direction which goes beyond the remit of the law to private parties? Recently, the court said, yes, this has to be negotiated between the employer and the employee. And all of this is directly relevant to what we are saying, because these are the same principles which will come into play. And lastly, a few days back, the court had stopped the famous Rath Yatra in Orissa, but 2 days later, again allowed it. This is just to show nothing is cast in stone. It's all doable, and the context changes the way things are looked at. So that's the next mantra that I'm saying, that it'll always be seen through a context and a lens which is very different from what we had seen in the past. And the next principle is creative solutions and innovation. So we have looked at legal innovation. The Supreme Court has talked about it. The Law Commission has spoken about it. The Prime Minister, when he announced the packages or the declaration of this 20,000 crore stimulus, had 4 L's. And one of those L's was law and the legal framework, as recently as a month back. So innovation and solutioning towards resolution is going to be a very important mantra, because while people may have triggered force majeure clauses, but it was really a very quick knee-jerk reaction to a situation which nobody anticipated, nobody thought of which way it's going to go. And equally, relationships are very important because for performance of contracts and completion of projects, it's important to have the relationships also intact. So resolution and creative solutioning and innovative thinking is another mantra which will have to be used by contracting parties to, as I said, to get on with it. And lastly, what I call commercial equilibrium principle, a little bit of fine tuning is sometimes the need of the hour because of the events which have happened. So while nobody intended somebody to bear additional costs, but costs have been incurred, somebody has to foot the bill. And that's where some amount of balancing to restore the commercial equilibrium would come back, as I said, going back to the first mantra, to make sure that the deal remains what it was at the time it was executed, and it is honored in the way in which the parties intended it to be. So these are some of the mantras which I suggest. Now, like businesses have challenge, the courts will also have challenges, and the legal ecosystem is also equally challenged. Therefore, a very important aspect, according to me, has to be that people who make claims or parties which make claims, they must be credible claims. They must be claimable. You have to be contract minded and claimable to be a responsible litigant, because when you go to a court and you present the full picture of what has happened, or to an arbitration in the event it goes to dispute, if you go as a responsible litigant with a credible case, with a fair claim, you will see a far more traction coming than in the past where people would bung in claims. And the responsible litigant will say, these claims arise purely because of COVID. Here is the documentary evidence. Here is the economic impact analysis I've done. And I leave it to a tribunal or a court to assess whether there's a causal link between the two. So just like the legal system has gone online, litigants and contracting parties also have to come up with a new avatar which will help them in this cause if they are making a claim which arises from COVID. And lastly, friends, and I want to end on a slightly humorous note here, that like I said, the mantras, if at all we have a prayer, what would be that prayer in this context? And the prayer in this context is, may the FM come to your aid. It's not just the force majeure clause, but it could also be the finance minister for the sectors. So what we really need here is some unconventional thinking, some out of the box creative solutioning, all aiming towards resolution, because that's the best way of dealing with the vast variety of issues which are going to come under different types of contracts, under different types of arrangements which parties have entered into and executed. So these are my opening remarks, so that we can think of some of the issues and the challenges and the questions in the light of these mantras and this kind of approach which I'm advocating for all of you to consider. Thank you very much.
Thank you, Mr. Jain, for this remarks of yours. Now, before we move to David's presentation on the international perspective of construction dispute, let me go to Anirudh to ask him about his opinion on the current situation of delays, disruption caused because of COVID-19. I've been getting a lot of requests wherein everybody is asking that how to tackle COVID claims, COVID-19 claims. So Anirudh, just a brief on that before we go to Mr. Jain and to you to discuss in details. How do you see the COVID-19 situation? What do you want and suggest a contractor and the employer when they are evaluating COVID-19 claims?
Thank you, Rohit. My video has been turned off. I'm not able to turn it back on. I don't know if
yeah, Deepak Sharma.
Yeah, let me begin while he.
Yeah, you can continue.
Works on this. Firstly, thank you very much for inviting me to be part of this fantastic panel discussion involving so many very interesting issues. Insofar as the issue that you have raised, now some party is going to suffer loss. The issue is, does loss lie where it falls, or can it be passed on from one party to the other? At the first instance, it is the contractor that is going to suffer loss. So under what circumstances can the contractor pass on this loss to this employer? Usually, the default position is that when there is a force majeure condition, loss lies where it falls, and that neither party can make a claim against each other. Now, this, of course, is dependent on the specific wording of the force majeure clause, because I have seen force majeure clauses that permit a party to make a claim limited to certain heads on the other party, right? So first point to keep in mind is force majeure is an entirely contractual issue. Just turning on the video. Yes. Force majeure is an entirely contractual issue. Therefore, on what is the consequence of a force majeure is dependent on the specific wording in the force majeure clause. Most force majeure clauses that I have seen would be wide enough to cover the present scenario of COVID-19 as well as lockdowns. There are some that explicitly mention epidemic. I think Steel Authority of India general conditions mentions epidemic. You have some that explicitly mention lockdown. You have others like the FIDIC clause that set out a wide enough test to cover the present scenario. Plus, in addition, you have all these government notifications that also sort of indicate that the present scenario is a force majeure situation. When can you make a claim, notwithstanding it being a force majeure clause? Broadly, there are two conditions. Firstly, if you're able to fit it within a special provision in the contract, like a change in law provision, or in some situations, a suspension provision, where suspension of the project by the employer may give, on any count, may give the contractor a chance to claim money. A change in law is more common because suspension provision is usually suspension by the employer and not as a result of an act of government. So a change in law would certainly be attracted based on the wordings of the clause, because the MHA orders pursuant to which the lockdown has been initiated is an order that is passed pursuant to the Disaster Management Act, and most contracts define a change in law to include a change arising out of subordinate legislation as well. Therefore, the argument would be that I would have worked 7 days a week but for the lockdown. Now, because of the lockdown, I've not been able to work. Therefore, as a result of change in law, I'm contractually permitted to claim. Of course, you will have to analyze the scope of the change in law clause, because some contracts do not even have a change in law clause, and other contracts may have a narrow change in law. For instance, a lot of contracts limit law to mean taxation laws. Therefore, it's important to keep in mind the specific wording. But the first broad head is there a special provision in the contract, like a change in law provision or a suspension provision in some cases, that permits you to claim? That's the first category. The second category is on the basis of the causation test, right? This would have two subcategories in it. The first would be if the loss is caused, if the disruption or delay is caused because of an earlier prevailing breach, and it is in effect as a result of the breach and not because of COVID-19 or the lockdown, then you can still make a claim. Let me give you an example. So if the site was to have been handed over to the contractor in January, and the site has not been handed over till date, and there is nothing that the employer can show to prove that otherwise the site was ready by March, then the real loss is caused. The dominant cause for the loss is not COVID-19, but the fact that the site was not handed over. In such a situation, a claim can be made. There is an English judgment, though it's not a construction case, there's an English judgment of classic maritime, where there was a breach by one party. That party had to ship certain goods. That party was in breach. They were not in a position to ship. But thereafter, there was a dam that burst in that area. And they said that because the dam burst, it's a force majeure event, and therefore they must be absolved of liability. The English courts held that the dominant cause was the actual breach, which occurred even prior to the force majeure event. And therefore, such a party cannot take advantage of the force majeure event. Therefore, you applying a similar principle, it can be argued here that if the actual loss is because of breach and not because of the force majeure, then damages can still be claimed. The second subset under causation could be where, for instance, the project was to have been concluded by February. It is the delay of the employer that kept the contractor at site even in March or April. Then, but for the initial delays of the employer, the contractor would not have been forced to go through this COVID-19 situation in the first place. Therefore, this would be a second scenario where the contractor can claim. Therefore, when you're asking me for my answer on this, broadly, first is based on a special clause in the contract. The second is based on the causal analysis test.
Thank you, Anirudh. Mr. Jain, now coming back to you, the industry is perturbed with the fact that the force majeure clause generally contains an entitlement for extension of time, but not for cost. So if a contractor is intending to compensate his losses by claiming cost due to COVID-19, how do you see this under the provision of the fact that force majeure clause only gives entitlement for time and no cost?
So let me straight away put into play one of the mantras that I mentioned to you, that while on the face of it, it's purely force majeure, but it is not just the epidemic. It's the lockdown, which were under government orders and instructions under the Disaster Management Act, and many such directives which have been given. So one way of looking at it, which I said, was the contextual interpretation test, and the dynamic law being a dynamic. You have to adapt it and see it in this rather holistic context and taking a far more practical, pragmatic view and the ground realities into account. It is not as a binary issue being squarely within one small pigeonhole. The second, the Supreme Court itself, in a case of Sarvesh Chandra, it was, I think, Justice Lahotti's judgment, does consider an exception in certain circumstances under Section 55 for making a claim for costs as well. But largely, it would also depend on the fact whether the contractor put the employer to notice straight away that, look, in this period, I'm going to ask for more compensation, or if he repudiated the contract. And third, and that's the reason why I gave all those instances, everything is doable in the Indian context because many things change. There's dynamic interpretation. And as I said, all decisions over a period of time will also find some amount of what I call fine tuning or rebalancing. If they feel the claim is misplaced, somebody has delayed the project and is using COVID to make a claim, it'll perhaps be rejected. But if somebody is able to show issues of viability for no fault of theirs, additional cost, and not just force majeure, as I said, but followed by a series of instructions which brought work to a complete halt, then you bring in also dimensions of change in law. And as I said, factors of reasonable compensation if causation is established. So which is why I had advocated, as you recollect in one of the mantras, that we have to aim towards resolution and some creative lawyering in the unprecedented context which has happened, with the object of keeping the original commercial deal intact. So these would be some of the ways in which, in a given case, these principles could be brought to play.
Thank you, Mr. Jain. To add to what Anirudh and Mr. Jain said, I would also like to say that, now because of this COVID-19, there has been loss of productivity of the contractors. For example, a simple example is that in one pickup or in one car, there used to be earlier 4 or 5 people who could be accommodated. Now it is just that 1 or 2 people are accommodated. There has been a lot of workers who have gone back, and as a result of which there is overall loss of productivity. So there is no strict idling is not there. So entire site is not suspended, but it is moving at a far slower progress rate than what it was anticipated. So there is what is called as the loss of productivity. Now, in case a contractor is intending to claim loss of productivity, then it has to be demonstrated that really there has been a loss of productivity, and evidence has to be there. Evidence is in the sense of that in good times, there could be a possibility that a contractor might be doing, let's say, 100 meter cube of concrete prior to COVID. And during the COVID period, also, he's doing 100 meter cube, but the plan was to do 400 meter cube of concrete. So therefore, in this case, a contractor might try to say that the differential between 400 meter cube of concrete and the 100 meter cube of concrete is because of COVID. But that's not the case, because prior to COVID also, the contractor was doing 100 meter cube per day of or per month of concrete. So it is important for a contractor to do what is called as a disruption analysis or a loss of productivity analysis. And also it is important for the employer to see that whether the claim which is coming from the contractor is due to the effect of COVID, due to what is the background, what is the basis of the claim. So here, what is called as a loss of productivity claim, and here what comes as handy for assessment and putting up the claim is the disruption analysis. So there are different types of disruption analysis. There are some things called measured mile analysis or earned value analysis, where a comparison is done for the progress or the rate of progress achieved during good times and during the time when this so-called disruption has taken place. So this is the basis of what we call as a loss of productivity claim. Now moving on to David now. So David, you are a renowned international practitioner of construction law. I would request you to give us your ideas and opinion about how construction law and how construction disputes are handled internationally in ICC arbitration, with specific focus to delay and COVID-19 claims. Over to you, David.
Thank you very much, Rohit. Just as I'm getting my sharing screen with everybody, because I'm going to do a few slides, I'd just like to thank Gopal for his mantras. And I'm not the only one, because a lot of the participants are very interested in these. And I'm going to invite Gopal not only to share them, but to write an article based on them. Very sorry, Gopal, you weren't waiting for that. I think everybody would like to see that.
Many thanks, David. I'll share it and write a piece.
Good, and you get your revenge in some other time. Now, my slides have not come up on the screen. I don't know what's happening. Don't know if anybody can help me.
Deepak Sharma,
is anybody the organizers who can tell me what's happening here? I don't know.
Just a minute, David. Deepak Sharma.
Okay. Well, anyway, let me just say very briefly. I'm one of more than 100 construction lawyers in Clyde & Co., which is a global firm. We have an affiliated office called Classis in India, and I've had the great pleasure of working on a number of international disputes with Indian contractors, and with Rohit. We've had a very interesting case recently as well, which is why I'm here today. So thank you very much, Rohit, for allowing me to be here. And I still don't have any slides, Rohit. So shall I just plow on and we'll see what happens?
David, if you can just again reshare the screen, you can just close it and again share it.
Okay, just give me a second. Now, while we're doing this, Rohit, as project manager, what is our time for completion on this project today?
So your time for completion, David, is another 15 minutes.
15
we are already
minutes.
running late.
That's an instruction. I'm going to claim extra cost.
Yeah. So you are the best suited lawyer for a contractor.
Yes, and yeah, hang on.
It's a compensable event.
Yeah, it's a compensable event. Great. I'm going to do this one more time.
Yeah, David, I think there's a problem with your...
I think you better do it like this only. We are able to see.
Yeah, right.
Once more. Right, off we go. 15 minutes. I'm going to talk generally about construction disputes, basically in ICC, arbitration. So I'm going a long way with COVID, but I'll be coming back to COVID on the last page, because there are a few interesting things to say from an international point of view. Now, what sort of arbitration is really good for international construction disputes? Do we want what they call institutional or ad hoc? Institutional means you're using rules, but to some extent, the procedure is supervised by the institution. Ad hoc means you're just using a set of rules and there's nobody else there. It's just the parties and the arbitrators. So in terms of advantages and disadvantages of the institutional arbitration, well, surely institutional arbitration means in principle more cost. It means you got delay because you got to wait until the institution has done what it has to do, and potentially interference with the procedure. Why not just let the arbitrators get on with the case? Now, I have done about 50, 60 ICC cases, basically construction, and a few which are ad hoc. And I can assure you, everybody, that it is worth paying the price in terms of the insurance policy of going to an institution that knows what it is doing, because in any arbitration, anything can happen. There are always surprises, and people are generally very happy to support and assistance of those at the institution. Now, ICC arbitration goes beyond just the institution. It's quite heavily administered, and there's quite a significant role for what is known as the ICC court. But remember, this is only the administrative body of the ICC. The arbitrators
ICC arbitration sir India के लिए applicable नहीं है ना?
Actually decide what is going on in the case. But there are significant support which can be very important. If you have problems appointing an arbitrator, or if you want to challenge an arbitrator, there's a very good system that works at the ICC and is rapid. And also, the ICC has a pretty unique role in that it takes on a formal scrutiny role in relation to the draft award to ensure that all of the formal requirements of the rules are met. That doesn't mean it has power to change the award, just to make sure that the content fits in with the rule. And I can tell you that when you've got an arbitrator who's not as good as he might be, that's quite useful, because it allows the ICC to intervene to some extent to improve the enforceability of the award, which is what everybody wants at the end of the day. Now, yes, administration comes with a cost. I say treat it as insurance, but how expensive is this insurance policy? Very quickly, I thought I'd just give you an idea of what an ICC procedure costs, especially if you don't do it. The arbitrators are paying a scale fee, which itself depends on the amount in dispute. And we'll give an example. The ICC admin fee is a fixed percent of the disputed sum. And if you want to have a simply go to the internet and you type ICC cost calculator, and that will take you straight to a table which you fill it in. So if you say that your dispute is, say, $10 million US, and you have a panel with 3 arbitrators, that will tell you what is the fee range for each of the arbitrators, and it is the ICC court which will decide how much the arbitrator gets within that range, and that depends upon how much time they've had to spend and how complex the case is. There you'll see the average overall fee for the tribunal, and there you will see the fixed ICC fee. Now, some of you may say $57,000 just for writing a few letters and perhaps taking a few steps. Well, in the overall, when you look at the overall cost of an arbitration, I can assure you that's very low, because the ICC's own research is that on top of all of the ICC and arbitrator costs, the costs of the counsel and of other people taking part in the case, expert witnesses, etc., is actually about 80%, if not more than 80% of the total cost. And so if you do the sums, that means that if insofar as the parties are sharing all of this cost, 50-50, ICC cost comes out at about 3%. And I can tell you from my experience, that is a very low amount to pay for what is quite an effective insurance policy. I'm trying to go as fast as I can. Now, ICC is a construction arbitration favorite. The latest detailed set of figures released for the year 2018 indicate that 27% of ICC cases relate to the construction and engineering sector, which is very high. And that is despite increasing competition from other major international institutions in Hong Kong, Singapore, and in London. One of the key factors for this relates to FIDIC. Many of you will know the ICC arbitration clause is to be found in the FIDIC contracts. It's been there since the first FIDIC contract in 1957. And every time FIDIC has updated those contracts, they've thought again, do we want to put ICC as effectively the default choice unless the parties choose something else? And every time they've said yes, because everybody is generally quite happy with the ICC rules. And I'll come on to why on the next slide. I would also mention, of course, ICC is based in Paris and was developed by people specializing in civil law back in the early 20th century. And there still is a slight preference of parties from civil law countries for ICC arbitration over rules from common law countries, which some people still think are more common law based. But that's not really true anymore. There's an incredible degree of harmonization among all of the international sets of rules. So, but it still, to some extent, explains why a lot of particularly French, Spanish, Italian contractors prefer to go for ICC arbitration. Moving on. What are the advantages? Well, these are a set of rules, but when you look at them, and when you, the listeners, who are, I think nearly everybody is Indian, I'll say basically common law background, it's more a sense of broad principles rather than extremely detailed rules to cover every single situation. I prefer to describe them as a flexible general framework that the parties and the arbitrators can and should adapt to the specific case needs of the case. Because as all of us who work in construction know, that the range of potential disputes on a construction project is almost infinite. There are no specific international construction arbitration rules simply because you cannot draw them up. You cannot foresee every type of dispute that's going to come up. So it's good to have a general framework, and in conjunction with that, often one uses other documents, such as the International Bar Association rules on the taking of evidence in international arbitration. Documents like this are very helpful. In the ICC rules also, there are, in the more recent edition, new rules dealing with the joinder of additional parties and consolidation of arbitrations, which are very important in the construction context, where we have quite a range of interrelated contracts. Final point, ICC rules, like others, have been really pushing for efficient case management and to minimize the time and the cost of the cases, and they have produced a set of guidance notes to help the parties and the arbitrators from this point of view. So that is my sale pitch for ICC. It can, and as I would say, it's not necessarily the only institution or set of rules which works. There are other matters, other points that really matter. And this brings me on to the question of expertise. Any party in an arbitration depends on expertise from all those involved at their various different levels. Your arbitration counsel, your lawyers have to have expertise, not just in arbitration. They have to be really specialists in construction. They have to enjoy construction, enjoy getting into the details of all of the different disputes, whether they be technical, whether they be delay related, whether they be quantum. That's very important. You have expertise at the level of the technical and other consultants who are outside of the company. That is essential, and it's essential they come in quite early on. That's going to be my next slide. So people like Rohit, you really need them from early on in any project, especially when you have a sniff of a dispute coming. Then there's the question of the quality and persuasiveness of expert witnesses. And I'll come back to this also on the next slide. And last but not least, and this is perhaps most important, the capability and the diligence of the arbitrators. This is the key issue. The French have a saying, which is that an arbitration is only as good as the arbitrators who manage the procedure. You can have the best rules, you can have the best counsel, you can have the best experts, but if the arbitrators don't know how to do the job and don't do it properly, you are going to have a catastrophic outcome in all likelihood. So you've really got to find good arbitrators. But where do you find them? This is the problem. Neither the ICC nor the FIDIC have official lists of arbitrators. So what I say there is, when you're looking for a good arbitration lawyer, You want somebody who not only knows the construction disputes and how to deal with them, you want somebody who knows all the good arbitrators. And that's my job as well. I have to know the good arbitrators to be able to say who will be the right one for a specific case, given the specific issues and the specific points that the party needs to persuade the arbitrators to accept. Should it be a lawyer or a non-lawyer? Okay, most arbitrators appointed in construction arbitrators are lawyers. But for me, there's an increasing overlap between the two. You find more and more engineers, quantity surveyors, etc., who have legal qualifications. You have lawyers who have spent, like me, 30 years in the construction world. That, you know, for me, the boundary between the two is starting to fade away a little bit. What about the president of the tribunal? This is the most important person. What is important here, again, is to try to ensure that it is the parties' choices of arbitrators or the parties themselves who try to agree upon who is to be appropriate president of the tribunal. Again, to try to ensure that you get somebody who can at least deal efficiently and with the dispute. Now, back to delay claims very briefly. Success in arbitration depends upon steps taken long before you start the arbitration. Delay claims, and I'm thinking in particular of the FIDIC contracts, which I've been dealing with throughout my career. They can only proceed, first of all, if you follow the contractual procedures. In particular, have you given that notice of claim in time? Because the risk, of course, under certain contracts like FIDIC is if you don't give it, you lose your whole right to claim. That's no good. You go right through all the procedures, setting up a detailed claim in accordance with what the contract requires. And then the evidence, of course, and I think Rohit will say this himself later on, there's a famous Irish construction professional called Max Abrahamson, who, when he was asked what were the three most important things in relation to claims, he said there were records, records, records. You have to make sure you have the proper foundations on which to build your claim, otherwise your claim will fall over quite easily. The quality of the initial claim is very important, because if you start changing the claim completely later on, that really raises some doubts in the mind of arbitrators as to what exactly is going on. Make sure the initial claim is good, and with a bit of luck, that initial claim will help you not go any further. Then, of course, you have to have a very well-developed initial claim, perhaps if you have an intermediate stage with the dispute board, and if on the dispute board you've got somebody like Rohit who's an expert in these matters, you've got to make sure that claim really stands up, and in many cases, matters get settled at the dispute board stage. So what I'm talking about is, okay, I'm talking about arbitration, but I'm really talking about how to avoid going to arbitration. And how to avoid going to arbitration also involves bringing in lawyers, consultants, and potential expert witnesses long before. They don't all have to have an open, a full instruction to do as much work as they want from day one on the matter, but you have to think with, perhaps with the assistance of the counsel and these consultants, as to what they can helpfully do to make the claim as strong as possible well before you get to the arbitration, in the hope that you can settle it before you get there. Specifically in relation to expert witnesses, I mentioned on the previous slide that we have to have experts who have both qualities and persuasiveness, because an expert witness, it doesn't matter how good he is on the technical or the delay or the quantum issue in itself and how good the report is in itself, that report will be tested in fire. It will be tested by the arbitrators. It will be tested and attacked by the expert witness for the other side. It will be tested by some possibly quite probing and difficult cross-examination. And then there could be this hot tubbing test where the two experts are together answering questions in front of the tribunal. You've got to find somebody who is really persuasive. So expertise in all these points, but also from a point of view of making sure that your claim can be successful in arbitration. Now, I've just 2 more minutes. I can only touch on the last point, concurrent delay, and then I'll say a few words about COVID. I'm glad to see that Rohit's going to deal with concurrent delay. All I would say at this stage is that internationally, it's a very vague concept. The English are obsessed by it. You have lots of court cases about it. To some extent, the Americans are interested, but I practice mostly in the civil law world, and nobody really knows very much about it at all. And when you look to contract terms for guidance, what I've quoted here is the latest edition of the FIDIC contracts, and that is very vague. A delay caused by a matter which is the employer's responsibility is concurrent with the delay caused by a matter which is the contractor's responsibility to be assessed in accordance with rules and procedures agreed by the parties, because there are no absolutely standard rules accepted by everybody yet. But what I would say to you, if you don't know about it, is type in the words SCL Protocol 2nd edition into the internet, and this will bring you up the Society for Construction Law Delay Protocol, which at core principles 10 and 14 will give good recommendations on how to deal from a time and cost point of view with the concurrent delay. And these are followed by pages of explanatory notes later on in the document. We would need a whole day to go through this properly. Perhaps we'll do with this Rohit at some other time, but that's not possible today. So let's get back to the beginning. Why are we here? COVID. We've talked a lot about force majeure, and as Anirudh has said, this is purely a contractual provision from the Indian point of view. Remember, force majeure is a civil law concept, and it is found in the codes of, I believe, more than 100 countries. So it is a legal concept. So internationally, if you're an Indian contractor and you're going off to work in a civil law country, you've got to look very carefully at what your contract provision says in compared to what the actual national law is, because you might not be simply applying what the contract provision says. You may, to some extent, also be subject to what the national law says. Now, what I would say very briefly on this is, from my experience, and again on FIDIC contracts over the last 3 or 4 months, when COVID started to move across the planet, everybody was saying force majeure, force majeure, force majeure. This was, to some extent, influenced also by an approach of certain Chinese entities, state entities, who were issuing force majeure certificates to their own companies, who were delayed in delivering supplies internationally. But I think the matter goes way beyond the question of force majeure or exceptional events, as this situation is now known in the FIDIC contract. Now, what I would just mention, as has already been said, we have the FIDIC clause, which is at clause 18, which does not specifically refer to epidemics or pandemics. Epidemics are referred to in the extension of time provision as a possibility, the base for getting an extension of time, but it is not in the FM clause. But the fact is that, to some extent, national courts have started to accept that COVID is a matter of force majeure, and there are French cases already to this effect. The general view that I have seen in articles and talking to colleagues is that COVID certainly would qualify as a phenomenon that fits in with the set of requirements defined in clause 18.1 of FIDIC. The FIDIC list is a non-exclusive, non-exhaustive list, fortunately. So yes, it probably is force majeure, but don't stop there, because, as Anirudh said also, it gives you time but no money. What I've found over the last couple of months is we've been looking at all the other provisions to see what they can go for. And we've already heard about some of these. The change of law. Many change of law provisions are very broad. And I've been dealing with one in Africa, which is so broad that it has really helped the contractor in particular to get more time and also more money. there are access to site issues, and you can get both time and money under the FIDIC provisions there. One special case that I've had, and this is my last point really, we've had one curious situation in which the employer decided, look, it's so bad, I'm just going to suspend the works, which is marvelous from the point of view of the contractor in a sense, because it gives him both time and money. But not all of the work under a contract will be suspended simply because you cannot go to the site or operate in the country of the project. And this also has started to raise issues. So there are lots of things up there in the air, but as others, I think Gopal have said, I'm afraid to say lawyers are going to be very busy and earn far too many fees out of COVID in all the disputes that are going to go through arbitration in the next year or two. And I should stop there. That's my throwing.
Thank you, David. Thanks a lot for this wonderful presentation and giving us an idea about ICC. Now moving back to the Indian law issue. So I've got a lot of questions related to COVID. Now, before we move on, my question to you, Anirudh, that you have a force majeure clause where pandemic is not defined. In that situation, can a contractor raise COVID-19 as a force majeure?
Yes, most force majeure clauses that I've come across are inclusive clauses, which refer to any condition beyond the control of the parties, including but not restricted to A, B, C, D. Therefore, even if pandemic is not expressly mentioned, most force majeure clauses that I've come across have been wide enough to cover the present situation.
Okay, thank you. Now, Gopaljan sir, question to you, that if the if COVID-related cost has to be claimed, and force majeure clause is silent on costs related to force majeure events, and if the contractor intends to bring this claim under the change of law, while the change of law clause is limited to change in taxation and all, so in light of the MHA and the Disaster Management Committee regulations, can a contractor try to claim cost for this COVID-19 related issues under the change of law, specifically when the change of law clause says that change of law related to taxation only is allowed?
So on a, again, going back to the mantra, if you take a very strict interpretation and the contractual provision has a narrow definition of change in law, obviously in the first port of call, it would be difficult to get over it because it is a defined term, one has to go by the contract. But again, as I said, if you look at it in the wider and the more holistic sense and give it a little bit of context, then I don't think the Disaster Management Act contemplated putting financial implications and obligations. It was really to deal with a disaster. Whether epidemic comes under that itself is subject to discussion. So at the end of the day, they will look at whether those costs are genuine, they arise from the situation related to COVID, and as Indian courts always do, see if some reasonable compensation is to be given. But like I said, we are just thinking of different situations without any particular case in mind. And like David was rightly saying, it's so dependent on a tribunal. If they take a very contract-minded technical view, they'll say you have to live and die by the contract, like the law lies where it lies. If you have a far more liberal, forward-thinking, this has completely changed the contours of the bargain, things have gone wrong, it's reasonable, it's well documented. In fact, the labor was not able to come, people were not able to work as efficiently as before because of social distancing protocols. There's a larger disruptive effect. Perhaps some of it, as long as it's well documented and causation principles are met, perhaps a claim may succeed. And we are going to see so many different permutations and combinations of this happening, and so many different courts and tribunals coming up with rulings. And that's why I gave those examples, which I always say, anything is possible when it comes to decision making in India. And we're going to see literally a floodgates opening on this count. And the Arbitration Act itself from 96 to 2012 saw 8 high courts taking 8 different views. And even after the amendment, different courts took a different view and the Supreme Court quickly stepped in. So that's that's the play of interpretation. It will be seen differently by different decision makers. So this is a possibility. But if a hard-nosed view is taken purely driven by the contract, then if it's a limited definition, perhaps the claim may not go through. But
Thank you, Mr. Jain.
one larger point I'm just making, that I think these are all cases where it's not just force majeure, not just change in law, it's A plus B plus, like we said, the larger disruptive effect, the loss of productivity, as you rightly mentioned, the new norms which are going to come into play. It completely alters the commercial substratum of the deal, which is why I go back to my first mantra. So some degree of practicality and ground realities will definitely be taken into account or factored in, especially if it's in tribunals and not in courts, because they may take a more commercial flavored argument, being commercial dispute resolution bodies. And like David mentioned, if you have the ICC, which is construction industry friendly, is familiar with it, and its decision makers are from that pedigree, they will assess the genuineness of the claims in the context of that particular case.
Thank you, Mr. Jain. David, I have got a question for you from the participants. The question is that if ICC comes out with some procedural order and one of the parties is not in agreement with that procedural order, then in that case, can the party challenge that procedural order issued by the arbitration tribunal, not by the Secretariat of ICC, but by the arbitration tribunal?
So the order is issued by the ICC court or is issued by the tribunal? Sorry.
By the tribunal. It's a procedural order which is issued by the tribunal.
Yeah, well, there are a whole range of orders which will be issued during the course of the arbitration. The formal position is it may be necessary to wait to the end of the case once the award is issued, and then to challenge the award on the basis that the procedural issue constitutes is a matter which is within the very limited scope on which you can challenge what the tribunal actually did, whether it did not act within the scope of its mandate, whether if the order is to say no, that party cannot produce new evidence, then there could be an attack on the grounds of a lack of due process. So that could be a real issue there. If it comes from the ICC court exercising an administrative power, then the only place you could go, I'm afraid, is to the Paris courts to challenge that. And I can tell you the Paris courts like to promote ICC arbitration. So I'm not saying that they are biased in any way, which is not true at all. It's just that it is very difficult to succeed in the Paris courts. It does occasionally happen, but I must admit these cases are few and far between because the ICC court have been operating now for 96 years. They know what they're doing.
Thank you. Thanks, David. Now, moving on to Anirudh. Anirudh, we come across several times situations where a contract has a clause that if a delay is caused by the employer, then in that case, a contractor is entitled to extension of time, but no cost. So even the delay events which have caused delay are not force majeure events, they are other events, but still a contractor is not entitled to claim cost and he gets only time. So I believe that you have been involved in similar kind of recent cases. What has been your experience? Can you explain?
Yes, Rohit, today I think it's become extremely common to find Indian infrastructure contracts have this term. And this is perhaps because there are about 10 to 12 Supreme Court judgments starting from Reddy's case in 1957 till the recent Virendra constructions, where the Supreme Court has taken the view that such a clause should be enforced. But if you are appearing for the contractor, there are a number of judgments that take a contrary view. None of the judgments of the Supreme Court refer to the other view. In the sense, the judgments that a contractor can rely upon do not refer or distinguish the judgments that say that such a clause has to be strictly enforced, and vice versa. So broadly speaking, there are 5 exceptions that can be carved out. The first would be the Sarvesh Chopra exception, where at the stage of seeking an extension of time, the contractor puts the employer on terms that notwithstanding such a clause, the contractor would be claiming compensation, and the employer accepts performance thereafter without murmur, then the employer will still have to pay compensation, notwithstanding an exclusion clause that bars compensation. The second exception is the exception of extreme delay. There are a number of judgments. There are Supreme Court and but you'll find 15, 20 different High Court judgments. I'm not going to go into each of those because I'll be talking for the rest of the time. But in case of extreme delay caused only by one party, caused only by the employer, then the contractor can make a claim. What is extreme delay? There are a number of judgments that go back and forth. The broad view is that if it's doubling of time, that is if a 24-month contract becomes a 48-month contract or more, then you can apply the extreme delay principle. The third is based on the old English law principle of fundamental breach, where the employer has fundamentally breached. And there are some judgments that set out what amounts to a fundamental breach, such as not handing over the site, not handing over the drawings, etc. In such a situation, there are Indian High Court judgments that have followed the old English law principle of fundamental breach and have granted damages, notwithstanding such a clause. There are two subsects of this. One is the argument based on Section 54 of the Contract Act, which gives you a right to claim compensation where a reciprocal promise has not been followed. Therefore, if, for instance, the employer does not hand over the land, that's a breach of the reciprocal promise by the employer, reciprocal to performance by the contractor, and therefore you have a statutory right to claim damages under Section 54. That's another argument that you can take. You also have the American concept of doctrine of active interference. There are two other exceptions which are rarer. One is on the basis that a clause that says no damages can be granted is against public policy and hence void. On the basis that today this hits at the very root of contract law. So the argument is that if a party is permitted to breach and there are no consequences, that goes against the fundamental principles of the Indian Contract Act in Section 73, and hence such a clause is contrary to Section 23 of the Indian Contract Act. The fifth argument is what I refer to as the Justice Karju argument, because he restricts such a clause in 2 or 3 different cases to say that this clause would not apply to an arbitral tribunal, but would only be applicable to a chief engineer who has to make a determination within the contract. Therefore, there are these 5 different carve-outs that you can argue. It's of course based on the facts and circumstances in that particular case that you will decide which one you want to press and which you don't want to. But it's important that contractors keep all of this in mind, and in fact so do employers, because if a contractor is trying to build a case within one of these exceptions, from an employer's point of view, they'll have to reply suitably during the period of the contract, right? So therefore, there are conflicting decisions. We have these carve-outs. There are also usually a lot of principles on doctrine of precedents that come in because there are multiple Supreme Court judgments of the same bench strength that take a conflicting view.
Thank you, Anirudh. That's quite helpful. Now, moving to you, Jain sir. I have a situation wherein a contractor has finished the job and he has his retention money and bank guarantee pending with the employer. The employer asks him to sign a no claim certificate stating that there are no pending claims, no outstanding issues. And once this is given, his retention amount and the bank guarantees are going to be released. Now, in that situation, a contractor signs the no claim certificate. So can the contractor, after signing of the no claim certificate, confirming that there are no outstanding claims raised against the employer, can go to the arbitration panel and the court and still raise claims in spite of signing of the no claim certificate? Your voice is mute, Mr. Jain.
As I hear you, there are 2 dimensions of the proposition. One is he signed the no claim certificate, but equally important was it was towards the culmination of the project. He needed the retention guarantees and other payments. So step 1 going back to another mantra, it will again be seen in the overall context and perspective that the two contracting parties, perhaps they were not of co-equal bargaining power. One party insisted that if you want your retention money and guarantee or any other certificate towards the closure, you will have to give the no due certificate. So that's step one, some degree of economic coercion or duress in issuing that certificate. Second, the certificate, even if given, it could be raised as a dispute by the party saying, these are the circumstances in which I have given it. I was compelled to do it for ABC reasons. And C, it will not be an isolated event of saying, oh, this by itself bars it. They will also look at the merits of the claim which is going to be made and consider it in its totality, which is why in India we have contextual interpretation, purposeful interpretation, and as I said, you will look at it as two parties, whether they were of equal strength or different strength. And if the other party, one which is given the certificate, can show by the timing that at the time when I gave the certificate, it was at the end of the contract, I was entitled to my retention money, guarantees, and other certificates, completion certificates, etc., then perhaps that would be a factor which would be considered by arbit tribunal and court, not in isolation to say it was a case of abject surrender. And we do know of some authorities which actually have made it into a standard modus operandi that when the contract is over and there no claims are coming, they ensure that a supplementary agreement is signed or an addendum is signed, which I call drop your trouser clause, that you'll give up all your claims. It's so against the grain of what is happening. It stands itself out to show it's abnormal. It was coerced, it was induced, it becomes clear. But that will again require a degree of evidence to be put. And in case after that no claim certificate was issued, the contractor immediately then goes back and says, look, this is the context in which it happened, right? So what I call some form of retraction or contemporaneous protest to show that it was circumstantial, it was induced, it was not voluntary, there was a degree of coercion, then all that becomes relevant. So again, it will just depend in the overarching totality of facts. It will depend on the decision maker. Somebody will say, you've given the certificate, it's binding on you, you have abandoned that claim, you can't make it here. But again, it's a subject matter of dispute which requires adjudication. It cannot be on a self-judged basis that one party tells the other, thank you so much, end of story, which is why we have impartial, independent adjudication, and it will go through that filter of adjudication. Rohit, I think
Thank you, sir. Thanks a lot. Question to you, Anirudh. When we are evaluating the claims from an employer or a contractor side, we very often come across what we call as concurrent delays. So it has never been a situation where it's a crystal clear case that only an employer has caused a delay to the project and a contractor has not at all caused a delay, or vice versa. So how does Indian law deal with this situation of concurrent delay? David has already talked about the Society of Construction Law protocol in his presentation about concurrent delay. Now, what has been your experience when you have dealt with these issues of concurrent delays, wherein both employer and contractors have delays taking place in the project? And how does a contractor claims the prolongation cost, and what should an employer keep into consideration while assessing such a claim?
Now, broadly, there are two methods that have been followed, two approaches internationally, and you will see a reflection of this under Indian law as well. The first is the Malmason approach, and the second is the apportionment approach. So before I get into these approaches, it's important to understand that when you speak about a concurrent delay, you're talking about concurrent events, one by the contractor, one by the employer, of almost equal causative force, right? So for instance, if the employer, the design obligation is on the employer, but the employer has not provided the drawings, and the contractor has failed to mobilize, even though mobilization should have happened by then these can be looked at as concurrent delays. But if say one is a much more minor delay event, then it would not even be a case of concurrent delays and none of these principles would apply. But if you find that say the project is delayed by a period of 6 months, jointly because the contractor has failed to mobilize and the employer has failed to provide the drawings, then in such a scenario, if you go by the malmason approach, you would have the contractor entitled to an extension of time and neither party can claim compensation for that period. If you go by the apportionment approach, you'll say both parties are equally to blame. Therefore, you will apportion the delay between the parties and say 3 months each, for instance. That is based on the causative effect. If you then say 3 months each, the contractor can claim unliquidated damages for the period of 3 months and will get an extension of time for the period of 3 months. And the employer can claim, in most situations, there'll be an LD clause, LD for a period of 3 months. And that would be the effect of the apportionment approach. Now, there is no clear standard across High Court judgments. By and large, when you look at Delhi High Court judgments, they have followed the malmason approach and Bombay seems to have followed the apportionment approach. But there is one judgment of the Supreme Court in Assam State Electricity Builders, which gives a hint. There is no express finding about any of this. But in that case, the arbitrator would have followed the apportionment approach. The award would have been upheld. Ultimately, it would have gone before the Supreme Court. And Supreme Court would have noted this and said there is no infirmity with the award. Therefore, it's possible to argue based on Assam State Electricity that implicitly the apportionment approach would follow, but you will find a number of Delhi High Court judgments that follow the malmason approach as well.
Thank you, Anirudh. To add to what Anirudh said is a very important point, that the causative effect, the dominance effect of two delays of employer and contractor has to be same to consider that as a concurrent delay. So therefore, if let us assume that a land was to be given by the employer, vis-a-vis during that time, there was a drawing to be given by the contractor. Now they do not have the same effect. The dominance of land not being available is far bigger as compared to a drawing, which otherwise is going to be constructed or erected on the land which is going to be given by the employer, has far less dominance as compared to the delay caused by the employer in giving land. So those two situations will not be considered as concurrent, number one. Number two, for a delay to be classified as concurrent, either of an employer or a contractor, both have to be on the critical path of the project, which means that the end date of the project has to be affected by that delay event. Many a times in my experience, what I come across is that, and I give this example very often, is that if a contractor has not constructed a roof of a room, vis-a-vis an employer has not given the drawing of a window. Now, drawing of a window is a very small delay and does not affect the criticality of the project. It's not on the critical path, but it is the roof of the room which has not been constructed by the contractor and has been delayed because of either lack of resources or for any reason is on the critical path. So in such a scenario, contractor cannot argue that because there was no drawing of a window, and as a result of which my delay in construction of a room should be considered as a concurrent delay and should be, I'm entitled for an extension of time or something. So important aspect is that for delays to be concurrent, they have to have the same causative effect, means same dominance, same potency, and secondly, they have to be on the critical path of the project.
And if I may just add in over here, so at a very practical level, you would split the project into small time phases, engage an expert such as Rohit to testify as to which is the dominant cause during which phase. So you may take a 15-day phase or a 30-day phase and say during this was the dominant effect. So you try and get out of this concurrent delay position by getting an expert to testify that during a period, in fact, there were no concurrent delay, but only one dominant cause. So in a lot of situations, you'll realize that there aren't concurrent delays because the two have vastly different causative impacts during a particular time period based on the targets that need to be achieved during the time period.
Right. Now moving to next question to David. David, under the FIDIC contract, what happens when an employer delays the payment or does not make the payment. So is the contractor, as per the provisions of FIDIC contract, ignoring the Indian law or any other thing, is the contractor entitled to slow down his work, stop the work if there is a delay or non-payment by the employer? David, you are mute. Yeah.
And I hope you can hear me now. Yes. FIDIC has evolved over the various editions on this, but the position now is that it's like a stepped approach to this, which involves notifications being given by the contractor. But very simply, the possibilities are, first of all, for suspension of some, of all, or part of the works. There are possibilities for slowing down, but notices, FIDIC, as we know, is a notice-obsessed form of contract. You have to give your notices on time to make sure that the engineer and or employer are in a position to react. But eventually, as you go up through this, you go up through suspension, and if you're still not getting payment, then you're going to end up in a position, having given notices, where you can terminate. And that is, you see it from time to time. I'm not too sure whether there are that many ICC cases on this. There are extracts that you can find about the application of the FIDIC contracts, but I'm not too sure if there are any ICC cases saying that the FIDIC approach is not accepted by local law. But as you say, all depends upon the interplay between the contract form and the local law, which is something I would like to hear about in India if you're using FIDIC, because it must raise lots of issues, because you have so much construction law, you must have so many mandatory provisions, but that's perhaps not something for today.
Yeah, you're absolutely correct, David. Now, my question to you on this, Mr. Jain, is that, as David pointed out, that the FIDIC forms of contract are loves notices. You know, a notice of delay has to be given by the contractor within 21 days, 28 days, and further details have to be given within 42 days. How does Indian law treat a situation where a contractor has not notified the claim to the employer within that designated period, or maybe slightly more than that? Does this mean that a contractor is barred from claiming his extra amount of money or time because he has not submitted his notice on time and as per the strict provisions of FIDIC contract?
So again, let me put it into two baskets, substance and procedure. So you will have Indian cases which say, let's look at the substance of it. It's a genuine claim. It arises from the contract. Yet he's not followed the strict process, the due process of the procedure. Somebody will fault, on the other hand, saying, if you've not given the notice within the particular time period and followed the procedure, you have disentitled yourself to it. But Indian law always have what is called reasonable compensation approach. So it may not be the only factor to deny the party, but again, it will have to be well documented. There'll have to be sufficient reasons made out as to why that process or procedure was not followed. And again, it will be a balanced approach between substance and procedure, so that there's no commercial injustice caused by not following the procedure. Neither should the person benefit by saying, I've woken up late, I've suddenly had a new idea, let me concoct something. So this would be the realm in which the decision makers would look at it. But it all, according to me, always goes back to the kind of decision maker stroke presiding arbitrator or the tribunal we have. It's very commercial minded. They'll say, look, you were aware of it, you signed off on it, you didn't follow the procedure, you bear the consequence. If you have the Indian judge mindset as arbitrator, he always allows a little free play for equity to come in. He looks at some degree of equity and justice. If he feels that, look, he may have missed it, let's say, by a short date, he didn't really intend to get any benefit from it, and give him some reasonable compensation. So you have different approaches. There's no one glove which fits the situation.
Thank you, sir.
Rohit, may I also just come in
Anirudh.
for a minute? I
Yeah.
have one more point to add on this. Now, one more thing in the Indian context is Section 28 of the Contract Act. And there are judgments that say that a clause that extinguishes your right if you don't claim within a specific time is contrary to Section 28. So that's another, so there's a Madras High Court judgment that explicitly states this. Madhya Pradesh takes a slightly different view. But this is also a factor that needs to be considered when you look at clauses like FIDIC 20.1 in the Indian context.
Thank you. Now, going back to Mr. Jain on COVID, I have a question from one of the participants where it is said that the Supreme Court has said that in case a party is not able to fulfill its obligations under the contract because of this COVID situation, the same can be considered as excusable. Now, in light of this, decision of the Supreme Court, what is your opinion that can the contractor still claim for additional cost and time because of COVID-19? So it's a situation wherein, a kind of Supreme Court judgment is there that let's excuse default by the contractor, which is what force majeure clause also says, that time extension can be given, cost will not be given. So something similar to that. So in light of this Supreme Court judgment, are you of the opinion, or what is your opinion, that can now contractors still continue to claim cost for COVID-19 defaults and delays?
Rohit, I don't want to comment on the judgment because I have not seen the judgment and the ratio in what context it is given, whether it's a judgment, it's a ratio, it was in the facts of that particular case. So it's very difficult to advise or extrapolate because, as you know, we have different kinds of judgments or orders which emerge depending on the fact situation. So I don't want to comment on it because I don't know, unless the participant can tell us in what context or the name of that judgment. It will be difficult to comment in the specific context of that judgment.
I agree, sir. I agree. So now moving on to the next issue is what we often find out is the issue of liquidated damages which are claimed by the employer owing to delays by the contractor. Now, question to you, Mr. Jain, is that let's assume a contractor has delayed the job. The contract has a provision of liquidated damages 0.5% per week with a maximum cap of 10%. Now, can the employer charge beyond this 10% maximum cap additional money related to losses which the employer is going to suffer or has suffered because of the delay caused by the contractor?
2 points. Before I answer your question, usually as the Supreme Court up to Kailashnath has always said, liquidated damages is subject to establishing actual loss. So first, a liquidated damages clause per se is not good enough. You have to establish some actual loss which is arisen. Second, the whole purpose of having a clause is upfront certainty that it's capped. So it will perhaps come in the way of an employer saying that I can exceed that amount because that is why you agreed at a genuine pre-estimate that you don't have to prove it. This is what will come in the event there has been a delay and the consequence. So on the face of it, it will be difficult to exceed that cap because there's a contractual threshold pre-agreed, brings in legal certainty into the commercial deal. You know that if there's a delay, this is the consequence. You can't cross the Lakshman Rekha. But again, as I said, even if you're entitled to an amount, it is subject to proving actual loss which is being caused. So it doesn't entitle you to that pre-crystallized amount. And sometimes some of these clauses have also been treated to be more like a penal clause or a clause in terrorism. So those styled as liquidated damages, but in the nature of the bargain and the context, could also be seen as clause in terrorism and penal clauses. So again, it really varies in the exact circumstances, the nature of the contract, the provision. But broadly, the answer to your question is they will not be able to exceed the amount which has been prescribed.
Thank you, sir. Now, David, this puts me to a question to you. You see, the Indian law says that in case an employer has to claim liquidated damages, it has to prove its actual losses. What is the position under English law?
The position under English law is quite different still. There was a big change a few years ago in what many people know as the Cavendish case, but it hasn't moved fundamentally away from the English position, which is, largely speaking, that if the parties have agreed and have made a genuine pre-estimate of what the losses are going to be, you do not really have to prove actual loss. So there has been a slight evolution, but not that much. And I just wanted to add here, this is one of the points on which there is still in principle, a huge difference between the common law and the civil law approach. Because liquidated damages is very much a common law concept which has no equivalent in civil law. In civil law, the clause, the term liquidated damages is translated as a penalty clause. Now, as Gopal was saying, we don't like penalty clauses in the common law world, but the civil law world has no problem with the notion of a penalty clause of penalizing a party for non-performance, particularly for late performance. But what you find, and what you have found in French law, almost going back to the beginning of the Civil Code more than 200 years ago, is that a penalty clause will be accepted and applied unless it can be demonstrated that the actual losses are extremely high or extremely low compared to the amount payable under the clause. And I have a memory of dealing with a case in a civil law country where the common law contract administrator said, look, you party, you are 4 months late, these are liquidated damages. And we were able to show, it took a long time, we were able to show that the actual loss was so low that that could not be applied. And what happens in that case is that the judge of the contract, in this case it was a dispute board member, said, I have decided to only apply to say that the amount applicable under the liquidated damages clause, because that's what it was called, even though the law was different, is a lot lower. So you have a completely different approach, going much closer to fairness than you still have, I think, in common law systems. Although from what Gopal was saying earlier on with the mantras, Indian law seems to be moving a lot closer to notions of fairness in many ways than I think many other common law systems are doing at the moment.
Thank you, David. Now coming to you, Anirudh, is the concept of unforeseeable conditions. I put to you a situation where a contractor is entering into an excavation project and there are some geotechnical reports which are attached to the contract, which are high-level reports. The contract has very clear provision which states that these are not relied upon reports and they are just being given for information's sake. So the information contained in these reports might change. And if there is any change, the contractor is not entitled to claim any cost and time because of this change. The contractor goes to site, he finds that the geotechnical report which was attached to the contract was totally wrong and there were ground conditions which were completely different from what were they specified in the geotechnical reports attached to the contract. Now, the contract has a clause of unforeseen circumstances where under one provision of unforeseeable circumstances, a contractor can claim that this situation was unforeseeable for an experienced contractor. Vis-a-vis, you have a clause which is very clear in that geotechnical report and other places that whatever is contained in this soil report is only for information and cannot be a issue for which time and cost can be claimed. Now, how does Indian law see this situation? I hope I have explained the scenario.
Got it. Now, Rohit, I think a lot turns on the design responsibility in relation to the project. Now, if the design responsibility is that of the employer, the contractor is only expected to mobilize and execute work pursuant to the drawings that are furnished by the employer. Therefore, the onus there is on the employer to ensure that the investigations are correct, so the drawings are correct. And in the event that the drawings themselves assume a different kind of conditions and that causes a delay to the project, the cause for the delay would not be the contractor's failure to examine the site, but would be the drawing failure, which would be the dominant breach. But if the design obligation is that of the contractor, then this obligation to be familiar with the site conditions gets escalated to a very, very critical condition, because the contractor ultimately needs to ensure that the drawings are perfect. So a lot would turn on whether it's a design build contract, where the drawing responsibility also is on the contractor, in which case it will be difficult to get out of such a clause. But if the drawing responsibility is on the employer, then in such a situation, the contractor can always argue that I am expected to mobilize and carry out works only pursuant to the drawing, and consequently, any delay caused due to these due to the ground situation is more because the employer failed in its design obligation. Therefore, again, you bring in this concept of business efficacy to interpret this clause on unforeseeable conditions and the duty of the contractor to actually study the site, along with what are the other critical obligations of the contractor and the employer in the context of the entire contract.
Thank you, Anirudh. Thanks a lot for that. Now, moving on to you, Mr. Jain, is that can there be a situations where an arbitral tribunal or an employer can levy losses or damages because of delay lower than the liquidated damages which have been defined and specified in the contract?
Yes, that is possible for the reason that I mentioned, that there will be an assessment of reasonable compensation which can be done by a tribunal, and that's the Kalashnikov principle upheld and recognized by the Supreme Court as well. So even if it's a pre-agreed amount, it doesn't ipso facto follow that you'll get the entire amount. Some element of establishing actual loss and reasonability, there is that free play which is available for a tribunal or a court to go into. So yes, that is possible.
Fine, sir. Thank you. Thanks a lot for that. Now these are some of my last issues and last questions. Coming to you, Anirudh. Under English law, there is a concept of practical completion, which I have not seen under Indian law. The concept is that, number one, the entire work is done, commissioned, and employer has started commercially utilizing the project. But the contract has a provision that liquidated damages stops only when overall completion is achieved. The meaning of overall completion is that the contractor has to submit the as-built drawings, complete all the snag list and punch list items, and finish each and every work and demobilize from the site, which is what is coming under the definition of overall completion. But the situation is that the contractor has finished the job, employer has commissioned the project, and has started earning revenue out of the project. So here I have two questions to you. Number one question, what happens if the employer has started earning revenue from the project, but continues to levy liquidated damages on the contractor because contractor has not achieved overall completion? That is number one. Number two, a situation where although the employer has not commissioned the project, is not started earning revenue, but the contractor has finished the job, and what is remaining are the minor snag items or the minor punch list items like as-built drawings and all those things. So in that situation, can the employer still continue to levy LD though he's not earning any revenue out of this? So you have two situations, and I would like your expert opinion on that.
Now, notwithstanding the clause that you mentioned, in both scenarios, in my view, liquidated damages cannot be levied for the reason that, as Mr. Gopal Jain was mentioning, in order to levy liquidated damages, you will need to establish loss. In the first case, the project's been commissioned and the revenues are actually being earned, therefore there's obviously no loss. In the second scenario, it could very well have been commissioned because what was remaining was only snag works. Therefore, if the employer did not commission it, it is for some other reason. Maybe there is another contractor at site who had delayed. In which means the loss that is caused is not because of the contractor who only has snag works left. So the first case, because in the first example that you gave, LD cannot be levied because of the principle that there is no loss suffered. In the second case, loss, if any, is not owing to the contractor, but some other causative effect. and therefore LD cannot be levied.
Thank you, Anirudh. Now, this brings me to a live example. We were recently in an arbitration around a year back, and it was one of the very big refinery projects in India. The refinery project was commissioned, inaugurated somewhere in February 2016 or so, and the contractor had completed the job, as a result of which commissioning could have been achieved. But what was remaining was those minor lists of issues, like, for example, demobilization, clearing of site, and various other minor activities, which the contractor took another 2 years to finish. Now, on one hand, the refinery was commissioned, it was inaugurated by the Prime Minister, and it was running, but the employer continued to levy liquidated damages all the way for those 2 years. Although, if the date of completion is taken as the date of commissioning or the date of inauguration of the refinery by the Prime Minister, then in that case, the contractor is not liable for any liquidated damages. But if the date of completion is considered as the date when all the other activities, those minor activities, were finished, then in that case, a contractor in such a situation was liable for LD. So the tribunal finally decided what Anirudh said, that there was no actual loss from the time beyond when the commissioning was done, the revenues were coming. So therefore, this concept of practical completion came in. David, would you like to add something on practical completion under the UK English law? You are mute, David. David, you are mute.
So I just wanted to counter, if I can, because your example is very close to a case that you and I know, Rohit. Well, I just want to give an example, just purely from the international arbitration point of view. I've mentioned that where you've got civil law applying, then in principle, if the actual losses are a lot lower than what the liquidated damages or penalty clause provides for, then you could get it reduced or even not to be applicable at all. But Rohit and I had the curious experience recently of being in a case where the facility was actually functioning in accordance with the performance requirements under the contract. It wasn't just a question of a few little things hadn't been finished, but it could function, and it was functioning. But there was a major liquidated damages claim made by the employer, and even though the arbitral tribunal was made up of civil law lawyers, they took a very strict, almost common law view upon this, saying, well, the contract says if you are late, that's the amount that you pay, and the contract terms have to be followed. So I just want to give this as another example of a case where you think your case might be quite good on the law, but it all depends upon the arbitrators that you choose. And that has caused a major issue, but there are other cases, most of the other cases I've had in civil law context come closer to the Indian context, where if the facility is operating, then the potential for applying the liquidated damages provision is very low, if not non-existent.
Thank you, David. Thanks for sharing this. Now, I have a question which I'd like to answer. The situation here is that there are multiple delay events which are attributed to the employer, and each delay event or a chunk of delay events have taken place at different point of times. Now, the question which has been put to is that, number one, should the contractor claim cost for individual delay events or on an overall basis for the prolonged stay? Number one. Number two is, let us say that the contractor has been delayed for the period between January 2020 to December 2020 because of the delays caused in the year 2018. Now, in that situation, what is the prolongation cost period which is going to be considered? Is it the additional time which the contractor has spent at site, i.e. the year 2020, or is it the time when the employer's delay took place, which is 2018? Now, there is a very big confusion which is prevailing in the industry, and let me clarify this. And based on my experience of having appeared as quantum expert in many arbitrations, you see, towards the end of the project, a contractor's expenses, especially the time-related expenses, reduces. Now, once those time-related expenses reduces, if 2020 is the period on which the prolongation claim is going to be calculated, the actual cost which the contractor has suffered or actual loss which the contractor has suffered owing to the delay caused by the employer will be less. Vis-a-vis in 2018, when the contractor's time-related costs were higher, were probably at the peak or near to the peak, the prolongation cost would be different. So a prolongation cost for 2018 and 2020 are different, although 2020 is the time when the contractor has spent that extra time beyond the contractual completion date, while 2018 is the time when the employer delay has actually affected the critical path of the project. So therefore, under various tribunals where we have appeared, and also as per SCL protocol and other guidelines, the actual loss of the contractor is when the 2018 delays were caused by the employer and not that additional time period which the contractor has spent in 2020. So this is a very big issue which I come across in majority of the claims submitted by the contractor. Number one. Number two, what should be a prolongation claim which should be considered? A prolongation claim only contains time-related costs, means costs which are affected because of the delay. Example, a welder who has been forced to spend extra time at site because of the delay, a contractor has to prove that this extra time spent by the welder at site because of the delay caused by the employer, or is it because the efficiency of the welder was low, or is it because the welder was sitting idle at some point of time because of reasons other than employer. So therefore, unless it is demonstrated that the direct resources which are being claimed under prolongation are because of the delays caused by the employer, direct resources are not part of the prolongation claim unless evidence exists pertaining to that. So therefore, again, what prolongation claim consists are the time-related cost and not the direct resources unless otherwise evidence is there for that. And this is very, very critical, especially when you have an international tribunal where you have the construction lawyers who understands the concept of time-related cost and the direct resource cost. I think now we are at 5 o'clock. This brings us to the end of our webinar. There were some technical issues in the beginning. Unfortunately, many of our participants could not participate and join in, and we are extremely sorry, but we have a full recording of this webinar, which we'll share with you in due course. And I see a lot of questions still coming from many people. What we are going to do is we'll be taking up these questions and replying to you one-on-one. I'll take inputs from Mr. Jain, Mr. Brown, and Anirudh and myself, and we'll reply to all these questions on one-to-one basis. Thanks a lot to everyone for joining, and hope to see you soon. Thank you, panelists. Thank you, David. Thank you, Mr. Jain. Thank you, Anirudh.
Thank you very much.
Thank you very much. It was a pleasure.
Bye.
Thank you. Goodbye.
Goodbye.